Hello.
Good. Before you'll speak, I make a short introduction, if I may. Azra Atalan is a legal procurement consultant at Covers Procurement Services. That's a consultancy, a legal consultancy, also or especially on public procurement in the Netherlands. We have also been in contact with Stefan Covers, who is heading this enterprise, Covers Procurement Services. The consultancy is specialized on pre-commercial procurement, public procurement innovation solutions, and PPPs. And this is also what Azra will be speaking today about innovation procurement. Covers has published a final report of the EC expert group on innovation procurement in November last year, overcoming legal barriers for the uptake of innovation procurement in the EU. That is a very interesting report. I will post it in the comments while Azra is speaking. Thank you so much.
Thank you very much for the introduction. Hello, everyone. I have been already introduced very nicely. Thank you very much for that. And it's a great opportunity to be here in this very nice conference with quite a lot of number of participants. So it's very exciting also for us to present this report. So here, looking at the agenda, after this introduction part, I will walk you through the work methodology, how we have conducted this study. This is a very extensive study. It involved a lot of countries all around the world, and I will be tackling how we engaged with the experts and how we planned the study. And then following that, I will be presenting the overview of the results. We have 6 key findings. It's a very extensive report, but I will be presenting it in a very briefly way. And then we have conclusions and recommendations for both EU Innovation Act and also for the procurement directives. And following that, hopefully we will have some time for open discussions. So I'm checking how to... Yes, please let me know if it doesn't work. I started navigating through the slides, so now I'm on the introduction page. So here, public sector is actually one of the biggest potential customers for innovation. Through public procurement, governments can play a key role in bringing new solutions from the lab into real use. So procurement is not just about buying, it is also a strategic tool to drive innovation. However, in Europe, innovation procurement is still not widely used, especially when we compare it to other major economies. And several important reports have highlighted this gap from, for example, the Draghi report, the Letter report, and the European Court of Auditors. And all of them point the same issue. The current EU legal framework does not sufficiently encourage the public buyers to procure in an innovation-friendly way. So this is exactly where our works come in. An expert group was set up to analyze this problem. We looked at how EU member states perform, and we compared this with other regions, non-EU regions. Based on this analysis, we developed concrete recommendations for EU action. And this comes at a very important moment because the European Commission is currently working on major policy initiatives, as already brought up in the previous session, in particular the Innovation Act and the revision of the public procurement directives. So the timing of this study is very relevant. And I'm moving to the next slide. And here I already mentioned the reports, and they all call for removing legal barriers. And these barriers prevent Europe from fully benefiting from innovation procurement. There are several key issues. Here you see the first, there is a lack of competition and transparency in procurement. This makes it difficult for innovative companies to find opportunities. And second, you see there is a lack of clear action plans. At both EU and national level, we often do not see clear goals, targets, or timelines. And third, financial requirements are often too restrictive. So they exclude startups and SMEs, and sometimes they even discourage large companies from participating. And there are also many practical hurdles. For example, too much administrative burden, slow procedures, and companies can be excluded for very minor administrative mistakes. And another important issue is overspecification. Tender documents often define the solution too strictly, and this leaves little room for innovative approaches and for flexibility. And IPR conditions are also problematic. They often limit the possibility to commercialize the results. And startups also struggle to enter markets dominated by large players. And these mechanisms, like multiple sourcing, are often too complex. On the other hand, contracts are another issue. They are often static. They do not encourage improvements after the contract is awarded. And there is also an unfair level playing field. Contracts are too often awarded based only on the lowest price. And finally, there is underuse of tools that could strengthen EU strategic autonomy, as well as a lack of simple frameworks for joint cross-border procurement. And at the same time, there is a huge potential, of course. If innovation procurement increases from 10% to 20%, this could generate around 3 billion euros in additional investment in Europe. So this would support growth, this would address societal challenges, and this would strengthen Europe's autonomy. Yes, so here in this slide, it shows how innovation procurement has evolved in the EU over time. So as you see, this is not a new topic, actually. There has been a long policy and development process behind it. It started already in 2005 with the Wilkinson report. Then in 2007, the PCP communication introduced pre-commercial procurement. And in 2009, funding was provided for networks of public buyers. Between 2011 and 2014, there was further funding under FP7 for PCP and PPI procedures. And in 2014, an important milestone, the public procurement directives were updated, and a broader R&D and innovation policy framework was developed with this. And in 2015, the EPPPL initiative provided tools and supported the public buyers, and it is ongoing. And between 2014 and 2020, there was Horizon 2020 and ESIF increased support. And in the current period, Horizon Europe continues this support, including full funding for PCP in some cases. And now we are entering a new phase. You see, in 2025, recommendations were developed for consultations on directives and the Innovation Act. These are based on the Innovation Uptake report across 33 countries that we will be tackling in this part. And for 2025 and 2026, the Soares expert group is also contributing, including work on defense and security procurement. So you see, this slide shows that there has been progress, but also it shows that we are now at a turning point. So if we look at the consultation on the Innovation Act, here in total, 2002 valid feedback submissions were received. The European Commission actively asks stakeholders for input, including through public consultations and position papers. So we also, as Covers, contributed to this process with our own position paper, which you can find the links in this slide. If the slides, I'm not sure if the slides will be provided, but at the end of this part, I will show you a QR code, which you can link to us to Covers, and then you can reach out and request it, and we can also share with you the materials, the links for your ease. And here, if we look at the respondents, we see a mix of companies, business associations, academic institutions, and public authorities. So there is broad stakeholder engagement. There were also several webinars. These focused on shaping the Innovation Act and discussing practical issues. And now what is important is the content of the feedback. So the chart on the right shows key measures that stakeholders support. For example, many respondents agree that public procurement should not be based only on lowest price. And second, innovation criteria should be used more. Legal frameworks should give more clarity, and procedures should be more flexible. And there is also strong support for better payment mechanisms, more transparency, and easier access for companies. So overall, there is a clear demand for more innovation-friendly procurement framework. Now, turning to consultations on public procurement rules, here the level of engagement was even higher. There were more than 1,000 feedback submissions. We also contributed to this consultation as Covers, and here you can find the links. And in parallel, there is also a consultation on Defense Directive. This focuses on simplifying rules for defense and sensitive procurement. And again, we also provided feedback there. There were also dedicated webinars. These cover topics such as innovation procurement uptake and rethinking defense procurement. So overall, we see strong engagement from stakeholders across different areas. Yes. Now I will move to the methodology, how we have tackled the approach of this study, how we engaged with the experts, and which template, which plan we followed. So first, we wanted to understand how innovation procurement can be further strengthened, in particular through changes in the legal framework. So we focused on three main aspects. First, we analyzed how current legal frameworks work at both national and EU level. And second, we explored what barriers exist and which techniques are already available but underused. And third, we developed recommendations to improve the uptake of innovation procurement in Europe. And this work was carried out in the context of expert contracts between DG RTD and the procurement lawyers. The results also feed directly into ongoing EU policy work, including the revision of directives and the Innovation Act. So this was a large collaborative effort. It was a very extensive study. We had public procurement experts from 33 countries. They worked together to assess the situation across all EU member states and also to compare it with the other regions, the non-EU regions, including the UK, the US, Canada, South Korea, Japan, and China. And this wide geographical coverage was very important. It allowed us to identify both weaknesses and best practices and to understand how Europe compares globally. So the experts were given several specific tasks. First, they analyzed the legal frameworks in their countries. They looked at whether innovation-friendly techniques are being used. And second, they identified gaps and barriers, both for public buyers and for companies for the supply side. They also reviewed case law at both EU and national level to understand practical lessons. And third, they proposed legal solutions both at national level and at EU level. And finally, they looked at global best practices to see what Europe can learn from other countries. So here you see the content of the report. It starts with an introduction and methodology, then it goes into the main barriers and gaps, and these are analyzed in detail. For example, we have action plans and targets, administrative burdens, financial restrictions, IPR issues, and cross-border procurement. And there is also a full overview of gaps in the legal framework. And finally, the report includes conclusions and recommendations. And there are several annexes, including case studies, case law, and country reports. So it is a very comprehensive document. So you can here we inserted a link. You can find the document, the full report through this link. So when it comes to summary, in Europe, innovation procurement is still seriously underutilized. One key reason is that the legal framework is not ambitious enough. So the expert group analyzed how to overcome these barriers. This was based on a comparison across all EU member states and also with other major economies. So the report provides a detailed analysis of barriers, lessons from other regions, and concrete legal recommendations. It also directly supports ongoing EU policy work. And finally, it includes detailed annexes with case studies and country-level insights. So I will dive into the content, the results. Here we will see the key barriers, the main findings, and possible solutions for them. And here you see the legal barriers to overcome. So here we summarize the main legal barriers. These are obstacles that explain why innovation procurement is still limited in practice. So first one, there is a lack of competition and transparency. many opportunities are difficult to find, and this makes it harder for innovative companies to participate. And second, there is a lack of strategic planning. In many countries, there are no clear national targets or action plans. So innovation procurement remains fragmented and inconsistent. And another key issue is restrictive financial requirements. These often exclude startups and SMEs. And even when they offer the most innovative solutions, it happens. So administrative burden is also a major barrier. Procedures are complex, they take time, and the requirements are often unclear. And at the same time, procurement practices themselves limit innovation. So specifications, sometimes they are often too detailed, and this prevents suppliers from proposing new solutions or find the flexibility to change their approaches or to make it more tailored. And contracts are also too rigid. They rarely allow improvements after they are signed. And finally, there are structural issues as well, fragmentations across countries, limited cross-border procurement, and unclear rules on intellectual property. So all these barriers together create a system that is not innovation-friendly. Let's look at the findings and how we can address them. So here you see the first finding, first key finding. It is regarding the national action plans and targets. Or more precisely, the lack of them. So most EU member states do not have clear national action plans for innovation procurement, and they do not have measurable targets either. So this is a major difference compared to other leading countries, where innovation procurement is guided by clear objectives. Without targets, public buyers have little incentive to act, so they often choose safer traditional solutions, which is buying the product directly from the shelf. And the study suggests a clear benchmark. Around 20% of public procurement should be dedicated to innovation, including both innovative solutions and R&D. So this would create strong demand and it would give companies the confidence to invest in more. To achieve this, we need coordination at EU level. We need a common definition for R&D and innovation. And we need common targets. At the same time, member states need to introduce reforms and plan investments more systematically. Innovation procurement should not be optional at this level. It requires that it should be a part of this system. Moving to the key finding number 2, this finding challenges the current approach, actually the innovation in all procedures. So in the EU, innovation is often linked to specific procedures, spatial tools designed for innovation procurement, namely PCP, PPI. But in practice, these tools are rarely used. Public buyers tend to stick to standard procedures, and because they are more familiar with the traditional procurement procedures, and it's less risky for them. So this means that having dedicated procedures is not actually enough because we already have them. So here we say innovation should not be the exception, but it should be integrated into all procedures. Every procurement process should allow flexibility and room for new ideas. Innovation can happen at different stages, not only at the beginning, but also during the implementation. So we need a system that allows adaptation and continuous improvements. And this also requires a change in mindset from risk avoidance to problem solving. Moving to finding number 3. So the third finding here focuses on how decisions are made. Today, many public buyers still focus on the lowest price, and even when the other criteria still is allowed, but this limits innovation. Innovative solutions often cost more at the beginning, but they create more value over the time. So the focus should shift from lowest cost to best value. These are already tools that support, there are already a lot of tools that support this. For example, functional specifications. They define the problem, not the solution. So this allows suppliers to propose new approaches. There are also innovation-related award criteria and value engineering approaches, which allow improvements over time. And here, intellectual property rules also matter. If they are well designed, they encourage companies to innovate. But today, these tools are underused. So the challenge is not to create actually new tools, but to actually use the existing ones. Checking the time. Yes. So the fourth finding is about access to the market. So here, startups and SMEs face major difficulties, even though they are key drivers of innovation. One problem is financial requirements. They are often too high. They exclude smaller companies, and another issue is complexity. Procedures are long and difficult to navigate. So here, payment delays also create problems, especially for companies with limited resources, for startups and SMEs. So they need money to make the work actually begin. And first, here, it is important to have more transparency. Opportunities should be easier to find. Second, more flexibility in requirements. For example, allowing alternative ways to prove financial capacity. And third, better financial conditions, such as faster payments or pre-financing. And finally, simpler procedures, less red tape, and shorter timelines. So with these, improving access would be go one step further. So moving to the key finding number 5, this is about fragmentation, and in theory, the EU is a single market, of course, but in public procurement, this is not the case. Rules differ across countries. In one country to another country, the public procurement rules differ a lot. So with that, procedures are not aligned. This makes cross-border cooperation difficult. Public buyers struggle to join forces and to procure together. As a result, demand remains small and fragmented. And this limits the attractiveness for innovative suppliers. It also makes it harder for companies to scale across Europe. So the study proposes a solution, a common framework for joint procurement. Sometimes it's called as a 28 regime. Maybe you have already heard them. This would allow simplify cooperation and reduce legal uncertainty. And by pooling demand, public buyers could reach critical mass and attract better and more innovative solutions. Yes, and in this regard, we are looking at the last key finding. So this is regarding the strategic dimension, reinforce the EU autonomy and resilience. Public procurement is not only about buying. We said it is also a policy tool. Other countries use it to support domestic industries and to strengthen their economies. In the EU, this approach is less developed. There are no strong mechanisms to prioritize European suppliers, especially in strategic sectors. This creates challenges both for competitiveness and for supply security. So the study suggests a more strategic use of procurement, for example, introducing bi-European approaches in specific areas. In specific cases, this would be more, I imagine, related to security and defense area. Or there are existing exemptions, so this could be used more often and more effectively. And the goal is, of course, not to close markets. I think there was a question about that in the previous section about opening the procedures, the procurement procedures to third parties access, third-party companies access. So, of course, it is important, but also one of the main rules here is creating the single European market. So for that, we should find a balance here. For some specific cases, especially for security and defense related issues, here there could be used more exemptions or more bi-European approach. But here, even with this one, the goal is still not to close the markets, it's to ensure the resilience within the EU. So to support critical technologies in the EU. So here you're looking at the life cycle of innovation and gaps. This slide visualizes the full innovation life cycle. It starts from idea to development and deployment, and it highlights where the gaps are. At the beginning, there is a gap in planning and in setting targets. This limits the creation of demand, and during development, there are issues with IPR. And with the use of procurement for testing and prototyping, But the biggest gap is at the deployment stage. Here you see innovations are developed, but they are not scaled. So this is due to the procurement practices and lack of demand at scale. And here, actually, we have a paradox because we see a strong R&D performance, but there is a weak market uptake. So this is actually an opportunity for companies to translate the strength into greater market uptake. Yes. So let's look at the math of the report. Here you see the color code description. So to analyze these gaps, this study uses a color code system. Each color represents the level of implementation. Green means the measure is available and clearly supported. And yellow means it is encouraged but not mandatory. And orange means it is optional with limited guidance. And red means it is not available or not properly defined. And this system helps us to compare countries. So you'll see it in the following slides in a bit more scary way. Sorry to put it that way, because you see a lot of red and orange colors, right? So here, this slide shows the results for EU member states, and the picture is quite mixed. Some countries have made progress with useful tools and guidance, but in most cases, measures are only optional or encouraged. Very few are mandatory, and this limits their impact. There are also major gaps in areas like national strategies, innovation criteria, and cross-border procurement. So the overall system remains fragmented. I would like to note that this analysis, the color coding, is being updated currently to reflect recent policy developments and reforms. So moving to the gap analysis in legal framework for non-EU countries, here you see the difference. Countries like the US and South Korea use mandatory approaches, not just recommendations. They also provide strong guidance and clear frameworks. Innovation-friendly IPR systems are widely used, which encourages companies to invest. They also promote practices like market consultations, market engagement, and value engineering. Overall, their systems are more structured and more directive. This creates clarity for both suppliers and buyers. And the key takeaway here, the EU has the tools, but not the same level of enforcement. So this is where the gap lies. So here, this slide focuses on the contract conditions. This is an important but often overlooked part of the procurement. In most EU member states, there are no standard contract clauses designed for innovation, and this creates uncertainty, both for buyers and suppliers side. Without clear templates, each country contracting authority defines its own rules, and this leads to inconsistency. In some countries, there are partial solutions, for example, optional clauses or sector-specific guidance, but these are not systematic and they are not widely used. This matters because contracts define what happens after the award, including how innovation can evolve during implementation. If contracts are too rigid, innovation stops, and even if it was allowed during the tender. So the key message was here that we need clearer, more standardized, innovation-friendly contract conditions. So you see the gap analysis in SMEs friendly legislation in EU member states. The overall picture suggests that most measures exist only as optional tools. Very few are mandatory. For example, advance payments or faster payments. These are critical for startups, but in most countries, they are not required. The same applies to reducing financial requirements or allowing alternative ways to prove capacity. And these measures exist in theory, but they are not consistently applied. Another issue is timing. Procurement procedures often take too long, several years, and this discourages smaller companies from participating. There are also gaps in protecting subcontractors, which are often SMEs. So overall, the framework does not actively support startups. It simply allows them to participate, and this is not enough. So here you see the gaps of SMEs-friendly legislation in non-EU regions. Here we have the chance to compare again with EU countries, EU member states, and non-EU countries. Countries like the US go further. They actively support SMEs. For example, they use advance payments more systematically and they enforce faster payments. They also introduce clear deadlines, so procedures move faster. In some cases, SMEs are even compensated for participating in procurement processes. There are also stronger protections for subcontractors, especially in countries like the US and South Korea. And importantly, financial requirements are better adopted. They are not a barrier. And so the difference is not about having the tools, it's about how strongly they are implemented, and non-EU countries use these measures more actively and more consistently. That's what the result tells us. So here, this slide presents the results of the expert survey. We conducted an also expert survey, and experts looked at around 3,700 procurement cases across all EU member states, and they checked how often key innovation techniques are used. The results are quite striking. Some techniques are used occasionally, but most are clearly underutilized. For example, leaving IPR ownership with the contractor or using functional specifications. So these are used in only about 1/4 of cases. And other techniques are used even less. Value engineering, for example, is almost never used. Financial support for SMEs is also very limited, such as advance payments or compensation for preparing the bids. And this confirms what we have seen before. The tools exist, but they are not widely applied. So, okay, so let's bring everything together. The main conclusion is that the EU has the right tools, but not the right level of implementation. Here, the recommendations focus on two areas, two pillars. First pillar is EU Innovation Act, and the other one is regarding the public procurement directives. So first one here is the first recommendation is to set clear targets, around 20% of total public procurement expenditure, with a specific share for R&D and for innovative solutions. This would create strong and predictable demand, especially in critical sectors. Second, we need national action plans. They enter innovation procurement within broader research and investigation policies. And at EU level, this should be coordinated with clear objectives and regular monitoring of progress. So third, joint procurement should be strengthened across member states. This would help overcome fragmentation and create larger markets for innovative solutions. Fourth, we recommend a buy-all type IPR regime for publicly funded innovation. This would better align incentives between universities, companies, and public buyers and support the commercialization of the results. Fifth, we need to increase incentives for universities to transfer and license their intellectual property. And the goal is to move towards a more commercialization-oriented approach that is also startup-friendly. And sixth, here you see we should introduce basic principles for all publicly funded procurement. So this includes startup-friendly criteria, stronger use of value for money, and limits on price-only awards. It also, of course, includes better timelines and protection of subcontractors, etc. So number 7, here we propose one uniform procedure and pro-commercial procurement of R&D with faster implementation and clearer rules across the EU. And the last one, we recommend introducing an EU preference for critical infrastructures, especially where procurement is not covered by international agreements. This would support strategic autonomy and strengthen resilience in key sectors. Checking the time. Yes, so the second pillar of the recommendations, they are on the directives. First, there is a need in clear and uniform definition of innovation procurement across all directives. This should align with the EU Innovation Act and clearly include R&D procurement and procurement of innovative solutions. Second, we need clear legal provisions to ensure the innovation principle is effectively applied. And public procurement should not block innovation. It should actively support it. And the directives should reflect this, but by making all procedures more innovation-friendly. Number 3, intellectual property rights need clarification. Tender documents should clearly define IPR allocation. And confidentiality must be also ensured throughout the entire process. At the same time, contractors should, by default, keep ownership with appropriate usage rights for public buyers, of course. And number 4, we should introduce a better recognition of excellence for research and innovation. For example, through certification mechanisms such as EU Seal of Excellence. 5, market analysis and open market consultations should become standard before launching procurement procedures. So this helps buyers understand the market and engage with suppliers early on. Number 6, companies should be able to easily find opportunities. More transparency is needed in this regard, for example, through improved use of TED notices, Tender Electronics Daily System, to signal innovation procurement more clearly. So number 7, we have in Article 32, 3A, this should be revised to better support innovation procurement. And this includes aligning with WTO GPA rules and allowing limited production of first solutions. It also includes clearer rules for initial solutions and encouraging joint procurement of R&D results. And next, the R&D services exemption needs clarification to avoid legal uncertainty. It should clearly confirm the use of pre-commercial procurement and ensure consistency with the EU treaty principles, the 4 main principles. And finally, the last but not least, security-related exemptions should be clarified to better define key concepts, such as essential security interests. At the same time, these provisions should support EU autonomy and resilience in strategic sectors. Okay, so I talked a lot. I hope I wasn't boring so much. So closing, finally, a short note. If you would like to stay updated on innovation procurement, you can follow Covers on LinkedIn. Here you see the QR code. You can simply scan the QR and it will directly link you to our page. And we regularly here share insights and research findings. And also, if you would like to receive those links and presentations and materials and etc., just drop us a message. Thank you.
Thank you very much, Azra. That was very extensive report covering a lot of countries. I think also very interesting to have like a comparison outside the EU. And let me see if there are any questions. Otherwise, I would jump in with a couple. So I would ask the audience, please, if you have any questions to Azra, post them in the questions and answers box.
Oh, they are asking for the
maybe
QR code
yeah
again.
Maybe you can put this up again so that they can get the materials.
Just a second. I think this one. Yeah. Let me know if it works.
Very good. So I have been doing innovation procurement research myself, and the big question in the room that might be an academic question, but maybe also not, what are innovative solutions and how can we define those? You were speaking about clear provisions.
Yes, exactly. That's a very good point, actually. That's where the gap lies. That's why you touch very burning points. We do not know, of course we know, but we do not have a legal definition for innovation, so innovative solutions, or for innovation, or for R&D. So it's fragmented. You can find a lot of information about the background of it, but whenever we are talking about the innovation procurement, we also have a methodology to, of course, to measure it. We are using the technology readiness levels, the TRL levels developed by NASA, and it starts from TRL 1, it goes all up to TRL 9. So if you are talking about innovative solutions, we are talking about between TRL 3 and TRL 9. So this is how we measure it. But what is it? It requires a unified definition.
Thank you so much for that. I think we got the first answer here from Luis Ferreira. He is asking, what is your view on the existence of national competence centers to support IPP?
So let me see. So here we are talking about the role and value of national competence centers for innovation procurement. I think, of course, they are very important because innovation procurement is a complex procedure, which is intended to be more simplified in the upcoming changes. And it requires legal and technical and market knowledge, and many public buyers do not have this capacity internally. For that, there are a few EU initiatives already to help them, to support them through this technical assistance part of it. Namely, also we are part of it as through SPIN for EIC and EFIP assistance. But also national competence centers can fill this gap. They provide guidance, they share best practices, they support concrete projects. That's how I would see it. But of course, yeah, again here, this is fragmented, right? If you are talking about the national competence centers, I'm totally speaking like country A, country B, probably it differs. So that's why also there is an alignment needed here. But I can already say that probably they help a lot. Yes.
Thank you.
I saw the last question as well. Do you think they should be EU supported? Yes, why not?
Very good. In the meantime, until we get maybe another question from the audience, I have one more. So you were talking about bi-European criteria. And when we think about buying AI systems, which are mostly non-EU, what would you consider in this situation?
So for AI systems, which is not widely EU, that is actually also, I believe, one of the triggers. That's why we are talking about bi-European, because let's not name them, but we all use some of the very major software solutions and also artificial intelligence that are not sourced directly in the EU. And these are subject to, unfortunately, sanctions, or let's say it that way, the political developments around the world affects a lot how to use the terms and conditions, the terms of use of these third-party providers, let's put it that way. So for this reason, as mentioned, it was also asked in the previous session, let's link all of it together. Yes, of course, it is important to open Europe to other markets, to third-party countries, and also associated countries with WTO and GPA. But also, it is important to create an EU resilience and autonomy in order to avoid any, let's say, interruptions or disruptions by the political developments.
Very good, thank you. We got another question from Gleb Kuka. He or she, excuse me, is asking, how can the procurement framework better support the acquisition of early stage innovative solution and where the risks are higher, but the strategic advantages can be bigger or more significant?
So how procurement can better support early stage innovation, okay, despite higher risk. So of course, my view is the framework needs to become more risk tolerant. First, use procedures designed for early stage solutions, for example, pre-commercial procurement, or a phased approach. You know, we have phase 0, phase 1, phase 2, phase 3, up until we go to the large scale deployment. So second, it is important to allow more flexibility. Not everything can be fully defined upfront. So iterative development should be possible. And I can think of the evaluation criteria. There should be probably a lot of adjustments there because, yeah, we are also dealing with a lot of PCP procedures currently. A lot of projects are ongoing. So we also have a lot of lessons learned there. And I can also think of the improve how to share the risks between public buyers and suppliers, because it's not like everything is guaranteed at the end of the day. But this is achieved again with phase contracts, because with the phase contracts, You have phase 0 for the preparatory activities, and then phase 1, and then only successful companies move to phase 2. And the successful ones move to phase 3. This way, you are actually allocating the risks. And whenever one of them failed, you don't have to invest them anymore. And everyone knows the evaluation criteria. So this also includes ensures the transparency. And of course, it provides, I believe, that financial support, pre-financing, we already tackled. I have already presented regarding those. It is a very important element to strengthen the framework. These are all I can recall.
Very good. Thank you. Thank you very much. Then maybe a last one, unless we get one from the audience. From my part, do we still need innovation partnership, or is functional procurement sufficient?
I can't say no, of course, but I think the procedures and how the procedure is applied matters. So innovation partnerships, of course, they can work. I cannot recall a current burning and ongoing example of it, but I can also remember a few examples that it really worked well. So whenever it is the problems that we have tackled in this study, they are valid for innovation partnerships as well. We can call it that way. And yes, for the right procedure, for the right elements, for the right dynamics, and they can really procure or more innovative, friendly solutions as well at the end of the day.
Very good. Thank you so much for this presentation and the extensive report that you linked. With that, I would say let's go into the second and last coffee break and continue at 3 o'clock with the topics on integrating bi-European and social and green procurement. And I leave the word to Björn in case he wants to say something during the break. Thank you.
Thank you.
Thank you very much, both Desiree and Azra, for the great presentation and discussion afterwards. While we're having this break, I want to give our editor from Lexxion for the Apple Journal, Morgan Soares-Astbury, a few minutes to present herself and the journal for those that might not be aware of it. Morgan. You're still muted, Morgan.
Can you hear me?
Yes, now I can hear you.
Okay, so hi everyone. My name is Morgan Soares-Astbury, as Björn said. I am the executive editor of the European Procurement and Public-Private Partnership Law Review, or EPPPL, from Lexxion in Berlin. I also edit Estelle, the European State Aid Law Quarterly, CORE, the European Competition and Regulatory Law Review, and EDSEC, the European Defense and Security Law and Policy Quarterly, which is Lexxion's newest excellent journal. I come to this role from Canada, which I think gives me particular appreciation for how distinctively European and how consequential this field is. So today I'm going to tell you a little bit more about EPPPL, which is a peer-reviewed quarterly journal that sits at the intersection of public procurement and PPP law, with a strong focus on European developments while also engaging with international perspectives. As Nelly mentioned earlier, we've recently welcomed Desiree Klingler as our esteemed managing editor, which is going great so far. We cover areas like EU legislative reform, national implementation, concessions, compliance, anti-fraud, sustainability, and more, with country correspondents and editorial board members spanning over 20 jurisdictions. Our articles are indexed in Scopus, JSTOR, and ProQuest, among a number of other databases. Now, what makes EPPPL particularly valuable for this community is its practical relevance. Alongside in-depth academic articles, we publish case notes and country reports that speak directly to practitioners, policymakers, and scholars working in procurement every day. In fact, several of the speakers you've heard from today are contributors and or board members, so you've already had a taste of the caliber of analysis that we publish. A journal like EPPL depends on its community. So if you're working on a paper or article reflecting on a recent case, or have insights from practice that you think deserve a wider audience or could benefit a wider audience, I strongly encourage you to consider contributing to EPPL. Author guidelines are available at lexion.eu/EPPL, or you can email pitches and questions directly to me or add me on LinkedIn, and I'll put that information into the chat. For those who are not at all familiar with the journal or would like to explore it first, we have made the most recent issue available as a free download until the end of the week. This one covers AI in procurement, contract modifications, the Buy European debate, and country reports from France, Greece, Italy, Slovenia, and Spain. So you'll receive a link to that issue in the email immediately following the council. And again, you can reach out to me if you have any questions. If you find value in this type of work and what we do, I invite you to subscribe to the journal or recommend the journal to your institutions, which significantly widens access to good expert-led information. So thank you very much. That's all from me, and I look forward to speaking with and hopefully working with many of you in the future.